With the criminal laws are set to change and implemented from July 1, today we are joined by Senior Advocate Indira Jaising, who has written to the Chief Justice of India, the various Chief Justices of the country, and to the Law Minister seeking a deferment of those criminal laws which are going to be implemented from July 1. Let's hear as to what are the contentions and why she wants a deferment of the implementation of these criminal laws. Ma'am, my first question to you would be, why are you seeking a deferment?
You see, with effect from 1st July 2024, we will have two different criminal justice systems in this country running simultaneously. So for any FIR lodged up to and including 30th June, it is the old law that will apply, at least the substantive law. For FIRs lodged after 1st July, we take it that the new laws will apply. Now you know that there are thousands of cases pending under the old law. They will continue to be governed by the existing Indian Penal Code, Indian Evidence Act and Criminal Procedure Code. But all FIRs lodged after 1st July will now be governed by the new three criminal laws. So you will have two parallel justice systems running in this country, criminal justice systems. Now, see, substantive laws are always prospective. So you can't apply the criminal law to the past. But you can apply procedural laws which are new to pending litigation, provided it does not cause prejudice to the accused. Now, what will happen in every case is the state will argue that the new criminal law applies. The accused will say, no, the new criminal law is prejudicial to me. The old criminal law should apply to me. Now, who's going to settle all these disputes? And how long is it going to take? You know, the pendency of criminal litigation in this country, in the district courts, in the High Court and in the Supreme Court is huge. You can say that there will be at least a 30 to 40% increase in that pendency.
Do you want to say that, the pendency will rather increase in after these criminal laws?
It will, because it might even double, because you have two different criminal systems operating. How will judges decide? In every case, if I'm an accused, I'll say, no, I want to be governed by the old law. And the state will say, no, the new law applies. Now, that decision will be taken first. Only then the case will proceed.
But these criminal laws were brought in only after talking to the stakeholders. The judges were consulted, the lawyers were consulted. A lot of deliberations have happened. So now, what is the issue? That obviously, the transition will take some time. But don't you think that the new laws have some kind of new changes in there?
Okay. First of all, you say all stakeholders. Tell me whether accused persons were consulted. Were they? Who are the people most likely to be affected by criminal law? It is the accused persons. They were never consulted. Did you actually go to them and say, this case is pending against you? Do you know that from 1st July onwards, a new law will apply to you, and explain to the accused what are these new laws? Secondly, substantively, many provisions have been introduced which will impact every one of our civil liberties. Were you consulted as a journalist? You weren't. Was I consulted as a lawyer who represents accused persons in court day in and day out of my life, especially on matters relating to bail, especially on matters relating to life and liberty? No. So you cannot give me this argument that stakeholders were consulted. Relevant stakeholders were not consulted. And if you do, now let me tell you what bothers me enormously. You know that Section 124A, which deals with sedition, has been stayed by the Supreme Court of India. What do you find in the new law? You find a reenactment of that law relating to sedition with additional draconian provisions. Whereas earlier there was nothing like impacting the sovereignty and integrity of India. The new sedition law talks about making any impact on the sovereignty and integrity of India an offense. Now, tomorrow if there's a riot, you'll say sovereignty and integrity of India is affected. Where are you? You are in prison, and you're in prison for indefinite periods of time. Look, ma'am, the average pendency of a case in this country is over 10 years, okay? So while you sit and figure out which law will apply. Is it constitutional? Is it unconstitutional? Your accused will be sitting in prison. How is this in the interest of the people of this country? It is not. Take another example. We have UAPA, Unlawful Activities Prevention Act, where offences of terrorism have been set out. Now those same offences are repeated in the new substantive criminal law. Why? Does it mean I'll face two short charge sheets? One under the UAPA and one under this new law. It's madness, because it gives to the state the power to choose which law to apply to a person, which investigating agency to bring into the picture. Should they bring in NIA? Should they bring in the local police? Now, these are the different ways in which it's going to impact our civil liberties. Now, all this requires a discussion. And ma'am, you can take it for granted that these will be challenged in the Supreme Court of India and any other important high court, constitutional court. Until then, see, criminal law requires certainty. And our old laws have been interpreted by the Supreme Court for over 100 years. So there is a certainty about them. Where was the need to repackage, reword, regurgitate the old law and make it complicated for all of us? For judges, for prosecutors, for lawyers, for the accused, and most importantly for the people sitting in prison. What are we talking about? Because when you said they have to come into force, they can't come into force until these issues are sorted out.
So, ma'am, what is your demand from the law minister who has just taken the charge?
A very simple request to defer the implementation of these laws until such time as relevant stakeholders have had opportunity to figure out where they stand. How does the old law compare with the new law? Will it negatively impact their rights under Article 21 of the Constitution of India? Can anyone give an answer to that question? No. Now, life and liberty is so precious that we can't have a vagueness about it. If I have committed a crime, I must know under which law I've committed it and which law will apply to me. From the 1st of July onwards, I will not know this answer to this question. I'll have to wait until the grand legal system decides which law applies to me.
Ma'am, the judicial infrastructure, if we talk about, the states had to form certain rules regarding the witness protection scheme, as well as on the aspect of that there should be a specific provision of audio-video recording of the testimonies of those witnesses. Ma'am, do you think that states are ready to it? I mean, leave aside Delhi.
Certainly not. I'm not aware of any rules framed under the new statute. When it comes to audio-video, ma'am, I cannot say that I have confidence that the audio-video recording will not be manipulated. Okay, what are the checks and balances in the system to make sure? And I'm not trying to, raise an argument of alarm. I am saying that every system must have written into it transparent checks and balances. Where are they for doing the audio-video recording? Okay. About 20 years ago, the Supreme Court said there should be audio and video recording of what happens inside a police station. It hasn't happened till today. Do your audio-video recording inside a police station so that we know whether the police are extracting statements from approvers, whether they are torturing the accused to give confessions. That is where you need it more than anywhere else. Witness protection, ma'am. Yes, Delhi might have a scheme, but it's a very inadequate scheme. Witness protection does not mean just money. Witness protection can go to the extent of changing my identity, giving me a new residence so that the accused can't get to me, so that the case doesn't collapse. Where are all those provisions in any existing law? There are none. So, certainly, there's one very important thing. I know that people have been praising this law, saying, well, we've introduced technology and the latest technology for purposes of investigation. Now, we are currently handling a case in Bombay where our argument is that materials have been planted. You can, by remote means, plant material on other people's computers. and it can be led as evidence in a court of law. Okay, so one of the primary things is that while conducting the investigation, while confiscating these devices, the hash value has to be taken. I don't find that in any law. So what's the point of all this technological progress? Is it just to prove to the world that we've made changes?
But the trainings are taking place day in and day out. The symposiums are taking place. The lawyers, the retired judges are giving those training to the judges. And the apprehension amongst judges is also the same, that, they are a bit confused, but they are saying that the transition will take some time. And the trial, which used to complete in 5 years, may take now 8 to 10 years to complete. Do you agree with this?
I agree, but is it fair? I agree with it, but is it fair to make an accused sit in prison while you sort out in your head what is the law? All right, then give an assurance that no one will be arrested till this transition happens.
But ma'am, sooner or later, these laws will have to be implemented because it has been passed by the parliament. So what is the suggestion that you can,
Well, for one thing, it was passed by the outgoing parliament. The new parliament is a very different creature. And therefore, I think the new parliament should be given an opportunity to relook at these laws.
So basically, you're saying the implementation should be halted, and these should be,
revisited. And ma'am, there's no question of sooner or later. Many of the provisions will be challenged in the Supreme Court of India. So that sooner or later will happen when the Supreme Court decides on the constitutional validity of some of these laws, the most critical portions of it. So there's even an astrologer can't tell you when these laws will be ready for implementation.
So basically, your contention is that, the system will be affected badly from July 1, especially for the criminal trials in this country.
Oh, yes. And in any case, criminal litigation in this country, let's say from a magistrate's court to the Sessions Court to the High Court to the Supreme Court, average time span is 20 years. Now, the average time span may exceed the time span of the accused persons. So we are all forgetting that the criminal justice system has to safeguard the rights of the accused. Yes, of the victim as well. But as you pointed out, there are no provisions for victim protection. So who is actually benefiting from these new laws? It's the state.
So this is what Ms. Jaising has told us, that, that there will be two criminal justice system in the country, and it will be the accused who will have to suffer more. With camera person Pradeep Gupta from New Delhi, this is Kanu Sarda for India Today.